Hi, everyone. I'm going to let everyone log in now that we're right on time and start up the closed captions. So bear with me for a minute. Okay, welcome everyone. My name is Christy Baglow. I'm the Director of Statewide Training at Florida Legal Services. And today we have a webinar about healthcare access. I hope everyone had a good, relaxing Thanksgiving, and I'm excited to see so many people ready to jump back in and learn this week. With us today, we have Margaret Kosyk. She's a senior staff attorney at Coast to Coast Legal Aid of South Florida, and she has got a really comprehensive presentation set up for us. It's scheduled for an hour and a half, so we should have plenty of time for questions, but we are going to save questions for the end of the webinar just because all these topics are so connected, and probably some of your questions will be answered as Margaret goes along. But if you're like me, you might forget what your question was by the end of the webinar, so feel free to type it into the Zoom Q&A box. That is easier for me to track than the chat box as far as questions, so feel free to enter those questions at any time, and we should have plenty of time at the end for Q&A. CLE has been approved, 1.5 credits have been approved, so I'll announce that number at the end. And this is being recorded, so you should all receive the recording link and a link to the materials by tomorrow from Zoom. So thank you so much, Margaret, for giving us this wonderful presentation today, and I will turn it over to you now.
Thank you, Christy, for having me. Hi, welcome again. I'm Margaret Kosyk. I'm a senior attorney at Coast to Coast Legal Aid of South Florida. And today I'm going to discuss healthcare access for low-income clients. At Coast to Coast, we have extensive experience in health law and poverty law. We have three main units: the Economic Advocacy and Community Health Unit that we call EACH, which handles public benefits. We also have a family law unit that assists victims of domestic violence. And we have a senior unit for clients 60 and over. So we provide advice, limited assistance, and representation regarding eligibility and coverage of medical services. We focus on Medicare, Medicaid, long-term care, institutional care, health insurance marketplace, and hospital financial assistance programs. Today, we're going to talk about a lot of different areas. As Christy mentioned, they're all very much integrated. We're going to talk about the health insurance marketplace, Medicaid, seniors, which will in itself will cover different top areas of health law: Medicare, long-term care, institutional care. We're also going to talk about another important population in Florida, immigrants. And then we're going to focus on an area that a lot of our clients have difficulties with, medical services and billing issues. And within all of these topics, I'm going to mention updates related to COVID-19. So let's start with the health insurance marketplace. Under the Affordable Care Act, states were required to create exchanges, which are basically like healthcare supermarkets where individuals can go and shop for health insurance. States like Florida were able to opt out and allow the federally facilitated marketplace, or FFM, step in. The official name of the FFM is the Health Insurance Marketplace, and it's run online through healthcare.gov. Federal subsidies are provided through the marketplace to lower the monthly premiums and the out-of-pocket costs. Anyone who is a citizen or lawfully present and a resident of a marketplace service area who is not incarcerated can purchase coverage through the marketplace. However, if you're receiving minimum essential coverage, such as through job-based coverage, you can't purchase a plan in the marketplace. In some cases, even if you're offered coverage, you can't purchase a marketplace plan. For example, if you're offered Medicaid, you cannot purchase a marketplace plan. However, if you're offered job-based coverage, you can purchase a plan, you just won't get subsidies. There are two types of subsidies in the marketplace. Advanced premium tax credits go directly to the insurance company each month to lower the monthly premium. Cost sharing reductions lower the out-of-pocket costs, such as copays, coinsurance, deductibles, out-of-pocket limits. In order to get APTC, advanced premium tax credits, a consumer has to have a projected annual income for the year of 100 to 400% of the federal poverty level. In order to be eligible for cost sharing reductions, the consumer has to have income between 100 and 250% of the federal poverty level. So to give you an idea, a single person would be eligible for APTC if his projected income for 2021 is between $12,760 and $51,040. However, in order to get cost sharing reductions, his income would only be able to go up to $31,900. In a household of four, for example, the household income would need to be between $26,200 and $104,800 for advanced premium tax credits, but it could only go up to $65,500 for cost sharing reductions. So this isn't something that you need to deal with on a day-to-day basis, but it helps to understand how the tax credits are computed, so that if a client comes to you and says, the premiums that I'm offered are just way too high, or there's no way I can enroll because I heard next year that the premiums are going to skyrocket. There is a set amount, what's called an expected premium contribution, and we'll go over that in the next slide. But basically, if somebody is eligible for tax credits, they're likely going to be able to find an affordable plan. So the way it works is the marketplace determines the premium tax credits by subtracting the expected premium contribution from the base price of the benchmark plan, which is the second lowest cost silver plan. The expected premium contribution is a set percentage that varies depending on the federal poverty level. Those percentages vary slightly from year to year, but not too much. It's basically going to be the same next year as this year, possibly a fraction of a percent higher. So, for example, an individual's expected premium contribution would be 3.11% of his income if he had 133% federal poverty level. And to put that in realistic terms, if his projected income is $16,971 for 2021, his expected premium contribution would be $44 per month. So what you do then is you subtract, once you've figured out the APTC, you subtract it from the base price of the premium that the individual chose, and then you would get the reduced premium. The health insurance marketplace uses modified adjusted gross income to calculate for eligibility in the marketplace. Generally, MAGI includes the adjusted gross income plus any tax-exempt Social Security, interest, or foreign income. MAGI does not include SSI benefits, for example, but it does include SSDI. A marketplace household generally includes the tax filer, the tax filer's spouse, and the tax dependents. Anyone who is married is required to file jointly in order to qualify for subsidies, but there are exceptions, such as for victims of domestic violence. Marketplace plans are divided into 4 metal tiers: bronze, silver, gold, and platinum. The consumer's cost-sharing responsibility goes down the higher the tier, but the premiums go up the higher the tier. So a consumer would be responsible for paying 40% of the cost of medical services with a bronze plan, but only 10% with a platinum plan. Obviously, the bronze plans are cheaper and the platinum plans are more expensive in terms of premiums. So if somebody is eligible for cost sharing reductions, they have to pick a silver plan because the patient responsibility for the silver plan goes way down with cost sharing reductions. Normally, a silver plan would have 30% patient responsibility. But if, for example, the income is below 150% poverty level, that goes down way down to 6%. So the best way to get an example of what premiums and out-of-pocket costs may be prior to enrolling is to use what I call the plans and prices tool. It's not on the healthcare.gov website homepage. You have to go in the search button and put plans and prices. Here's an example. I put in the information for a 42-year-old woman from Broward County who expects to earn $13,000 for 2021. I discovered that she would be eligible for $416 per month in tax credits plus cost sharing reductions. So you can see it's a little bit small, but you can see that the top plan is a bronze plan that's available to her. There's 0 monthly premium. However, the out-of-pocket maximum for that plan is $8,550. That means that all of her co-payments, co-insurance, and everything for the year could go up to $8,550, but not beyond that. The insurance company would cover the rest. So that's a large amount of money for a low-income client. The bottom plan there is a silver plan. It's the 6th most expensive silver plan, but I chose it because of the out-of-pocket costs. You see the premium is relatively high for somebody whose income is $13,000 for the year, but it's $38.69 a month. But that out-of-pocket maximum is only $800. So, somebody could have $500,000 or more in medical bills or medical costs and only have to pay $800 for the whole year. So open enrollment for the health insurance marketplace is November 1st to December 15th for 2021 coverage. So that deadline is fast approaching. However, consumers can still enroll if they're eligible for a special enrollment period. The best way to enroll is with the help of an enrollment assister, but you can also apply online. If for clients who are computer savvy, they can go to healthcare.gov and create an application themselves. You can also call the call center. That works fairly well, but I think that the best is to have a local enrollment assister. Some of them are working remotely, but some of them are also still working in the office. So the two types of special enrollment periods are life events such as marriage, moving to a different coverage area, or having a baby, and complex cases such as victims of domestic abuse or becoming newly eligible after being in a coverage gap. We're going to go over that in a little bit. In 2020, consumers who qualified for a special enrollment but missed it due to COVID-19 could qualify for another special enrollment period. And anyone who lost coverage since January 1st, 2020 would be eligible for an automatic special enrollment period due to the COVID emergency. These are essentially irrelevant now since there's no need for a special enrollment period in 2020, but we may expect to see similar COVID-related special enrollment periods for 2021. So since the advanced premium tax credits are based on projected income, the premium tax credits need to be reconciled based on actual income when the consumer files their income taxes. So if a consumer had higher income or fewer household members when they filed their taxes than they had projected, then he or she could be required to pay back any excess tax credits. And vice versa, if they actually had lower income or more household members, then they could actually get more tax credits when they file their income taxes. So anyone who received advanced premium tax credits the previous year is required to fill out an 8962 form. They will get a 1095-A from the marketplace, which will show the advanced premium tax credits that they were given. They use that 1095-A form to help when they're filling out the 8962. Then they calculate the difference between the premium tax credits that they should have received based on their actual income and the advanced premium tax credits that they did receive. So if the APTC was too high and ended up in an overpayment, there are caps on penalties depending on the poverty level. So anybody whose income was under 200% poverty level, for example, would not have to pay more than $300 or more than $600 if it's a family. So although Congress set the penalty for not purchasing minimum essential coverage to 0 in 2017, the individual mandate that requires people to purchase health insurance is actually still in the Affordable Care Act. So you may have heard of California v. Texas. The Department of Justice in several states, including Texas and Florida, are challenging the constitutionality of the ACA again. They contend that without the penalty, the mandate is unconstitutional. And because the mandate was so interwoven with other provisions of the Affordable Care Act, the whole law should be struck down its entirety. During the U.S. Supreme Court oral arguments, Chief Justice Roberts and Justice Kavanaugh pointed to the doctrine of severability that calls for the court to preserve the rest of the law when it is struck down. A final decision will be made on that at the end of the term. So here's a good example of tax credit reconciliation issue. This client had been getting marketplace coverage, and she had been eligible for the exception as a victim of domestic violence, allowing her to qualify for tax credits, even though she was married and filing separately. As I said, you're supposed to, in order to get tax credits, normally you would have to file jointly if you're married. She received a notice from the marketplace that her insurance would be canceled because she did not complete the 8962 when she filed her 2018 income taxes. She called the IRS, and the representative had erroneously informed her that since she's married and filing separately, she cannot file an 8962 form. I advised her that that was incorrect, that she should fill the 8962 form and check there's actually a box at the very top of the form that says where you can attest that you are a victim of domestic violence and that you qualify for the exception. I then advised her to file an amended return with that 8962. She said, so one thing that's important with that is the 8962 instructions say that you need to have some kind of evidence of the domestic violence situation, and there's several types of evidence. You don't have to provide it when you file your taxes, but you need to have it on file in case you're asked about it later. I originally had advised her to go to volunteer tax assisters, and initially they were willing to help in filing the amended return. But when they found out that she was married filing separately and planning to check that box that said she was eligible for the exception, they told her that she had to provide a police report. Well, that is one of the types of evidence, but it's not the only type. As I said, she was able to provide a statement from her brother who witnessed the abuse, and that was sufficient. And she just needed to keep that in her records. She shouldn't have even had to provide that for the volunteer tax assisters. Eventually, the client and her brother were able to get it completed and filed and submitted the 8962 with the amended return, and she was able to get re-enrolled. So an area that seems to lead to a lot of marketplace appeals is data inconsistencies. The marketplace uses what's called the Federal Data Services Hub to get information from the various agencies such as Social Security, the IRS, and the Department of Homeland Security. If a consumer's information in the application can't be verified through the Data Services Hub, the inconsistency process is triggered. If there's a data inconsistency, consumers will be asked in the initial eligibility notice to provide proof of income, immigration status, or minimum essential coverage like Medicaid. They have 90 to 95 days to provide the documentation. If the data inconsistency is not resolved, consumers could lose their coverage. One of the best ways to provide that information, that verification documentation, is in the online application. But you can also mail it in. There aren't that many types of decisions that can be appealed directly through the health insurance marketplace. Primarily, it's eligibility to purchase coverage or tax credits. You can also appeal eligibility for a special enrollment period. The best way to appeal is to use the appeal form on healthcare.gov and attach a letter of explanation. There's also an authorization representation form that they'll need to fill out if you're going to help them. Generally, the consumer has 90 days from the date of eligibility, the date of the eligibility notice to appeal. So let's move on to Medicaid and the coverage gap. So Medicaid is essentially free health coverage provided through a federal-state partnership to people with low income. There are several types of Medicaid, but the one most people think of is the full health coverage type of Medicaid. Traditionally, you have to have a categorical connection in order to qualify for that full health insurance Medicaid. So you have to be a pregnant woman, a child, a parent caretaker, blind, disabled, or 65 and over. So as I said, Medicaid is a state-federal partnership. The Centers for Medicare and Medicaid Services, or CMS, administers Medicaid at the federal level. At the state level, the Agency for Healthcare Administration, or AHCA, administers it in Florida. So there were several changes to Medicaid under the Affordable Care Act. The biggest change is that it was expanded to anyone with low income. Anyone below 133% poverty level was supposed to get Medicaid, regardless of having any kind of categorical connection. As you may have heard, the United States Supreme Court found that the federal government could not force states to expand, and they were able to choose whether or not they would expand. So far, the Florida legislature has chosen not to expand. So anyone with low income in Florida has to have that traditional categorical connection in order to qualify for Medicaid. Anyone who does not qualify for Medicaid, if either their income is too high for Medicaid or they don't fit into that Medicaid category and their income is too low for marketplace subsidies, they're in what's called the coverage gap. This is a pretty good graphic of the coverage gap. So you see that there are many types of people that fall into that coverage gap: veterans, working parents, low-wage workers. One of the clients that we see the most, I think, tend to be people who have chronic illnesses or injuries, but have difficulty, jumping through the hoops to get Social Security disability. So modified adjusted gross income, or MAGI, is used for family-related Medicaid as well as the health insurance marketplace. It's very different from the way the income was previously counted for Medicaid, since it does not count things like child support or SSI. One thing to note is that MAGI does not count assets, only income. So this is the financial criteria for family-related Medicaid. This chart is a little complicated to read. I don't know if you can see that very clearly, but you'll see that there's what's called a standard disregard and Magi disregard there at the very end. Some categories have the standard disregard. Some will just use that Magi disregard. That's just an amount that is added on in order to calculate the income limit. So, for example, the limit for a single parent and a household of 2 is $241 a month. Then you add the standard disregard of $146 and the Magi disregard of $72. So the total amount income limit for a single parent in order to get Medicaid is $459 a month. By contrast, the limit for a 10-year-old child in that same household would be $1,911 a month, plus the Magi disregard of 72 for a total of $1,983. So you can see that $459 for a parent is much lower than the $1,983 for a child. The Department of Children and Families determines eligibility, except in the case of SSI Medicaid. Applications have to be processed within 45 days, but it could end up more if the applicant does not provide the requested documentation or contact the interviewer. That can be a problem because the interviewers generally leave messages, but oftentimes they do not answer callbacks. The best way to apply is online at the Florida Access online. People can also call customer service since the offices are currently closed for the coronavirus emergency. Another reason to call customer service is if you do have a problem with that interview, getting in touch with that interviewer, you can call and answer the questions just by calling the customer service number. So qualified hospital providers may elect to make presumptive eligibility determinations for the following groups: pregnant women, parents, caretakers, infants under the age of 1, children under 19, and former foster care children age 18 to 26. Citizenship and non-citizen status are not factors of eligibility for presumptive eligibility for pregnant women. So here's an example of sort of a Medicaid marketplace combination. A client came to us in August 2020 because he applied for Medicaid, but he hadn't yet received a decision. He was married. He and his wife had lost their jobs in March 2020, and they were receiving unemployment benefits totaling $348 per month. He was 31 years old. He didn't have any minor children. And since he could work, he was not considered disabled. So it appeared that he did not fit into any of those traditional Medicaid categories. So I advised him that he would likely be denied Medicaid, and he could appeal, but he would not be successful on appeal. He said that the total household income that they would likely make for 2020 was probably going to be around $45,000, that included the state and federal unemployment benefits. So I advised him that they should be eligible for marketplace tax credits since their income was between 17,240 and 68,960. As I said, they lost job-based coverage after January 1st, so they were eligible for that COVID-19 special enrollment period and were able to apply. So traditionally, Medicaid providers contracted directly with the state. That's referred to as fee-for-service Medicaid. With Medicaid managed care, the state contracts with a managed care organization, which then contracts with a network providers. So it's a little bit more, it works a little bit more like a private insurance plan. Florida's Medicaid reform. Florida was granted a waiver to shift beneficiaries out of the fee-for-service model and into managed care plans. So now Medicaid recipients can receive, well, they do receive medical services through the managed medical assistance program or the long-term care managed care plan. Medically needy is for people who, it's a type of Medicaid. It's for people who fit into the traditional Medicaid categories, but their income is too high for that particular category. As you saw earlier, a parent of a minor child has a very, very low income limit. So you frequently see parents who are eligible for medically needy. It works a little bit like a low-cost bronze plan. They're assigned what's called a share of cost. So it acts a little bit like a deductible where the medical bills have to meet that share of cost in order for Medicaid to open and cover those bills. It's a little bit more expensive, more complicated than that. It works best for people with high medical expenses like prescriptions. So we usually advise people with a lot of prescriptions to go, to get those filled at the beginning of the month. That way, if the Medicaid opens early, then they'll be covered for the rest of the month. The Children's Health Insurance Program, known as KidCare in Florida, is for children in families that earn too much money to qualify for Medicaid. Premiums are $15 to $20 for people with low to moderate income. The full pay option is $215 to $230 for families with higher income. So I'm just going to brief over disability a little bit as it relates to healthcare. Social Security Disability Insurance, SSDI, provides benefits for individuals who have sufficient work history who are currently unable to work due to a disability. Anyone who qualifies for SSDI can get Medicare 2 years after receiving the SSDI benefits. A lot of people are confused by this and don't really understand what to do, how to get health coverage. A lot of times people are, their SSDI benefits are high enough to qualify them for marketplace subsidies. And as I said, SSDI does count for eligibility, financial eligibility for subsidies in the marketplace. Supplemental Security Income, or SSI, is for low-income individuals who don't have a work history, who are currently unable to work due to disability. Anyone with SSI automatically gets Medicaid. So what happens if you're disabled and you don't have SSI? So even if an individual is denied SSI, they may still be eligible for Medicaid if their condition worsens. There's a standard form that they receive after an SSI denial that says, an application for SSI is an application for Medicaid, and even if you were denied SSI, you could still be eligible for Medicaid. That confuses a lot of people because they get it and they say, oh, look, I was denied SSI, but I'm going to get Medicaid. Well, all it does is just say that they can be reassessed for other Medicaid categories like family-related Medicaid, or if they attest that their condition has worsened, they can request an independent assessment. Also, another complaint we receive from clients is that DCF tells them that they have to apply for Social Security disability prior to applying for Medicaid, or that they have to wait for the SSDI or SSI decision. That's not true. Individuals can apply for Medicaid and check disabled, even if they have not applied for SSI or SSDI. Also, the state has 90 days to make a decision, so they can't wait for the SSI or SSDI decision, which could take a lot longer. A fair hearing must be requested within 90 days of a notice of case action. Individuals can call the customer service number or email the appeal request. As I mentioned, anyone not eligible for Medicaid or marketplace subsidies is in the coverage gap. However, they're not entirely without options. Charitable hospitals are required to have a financial assistance policy for anyone under 200% of the federal poverty level. Individuals can see primary care doctors, see specialists, get any medically necessary procedures, and get emergency care, all for very low copays. So anyone who has been in the coverage gap but whose income increases may be eligible for the health insurance marketplace subsidies if they become newly eligible, and they may be eligible for a special enrollment period that we refer to as the coverage gap SEP. So in order to qualify, they have to have lived in a non-Medicaid expansion state, such as Florida. They have to be ineligible for tax credits in the marketplace solely due to household income below 100% poverty level. They have to simultaneously be ineligible for Medicaid. And as I said, they have to become newly eligible for tax credits because of an increase of income or a move. So Medicaid cannot be terminated during the COVID-19 emergency period unless the beneficiary moves out of state or voluntarily withdraws. Also, the postpartum 60-day cutoff for pregnant women or for women has been suspended. Florida Medicaid is covering COVID-19 testing and medically necessary treatment. Anyone who is uninsured is treated for COVID-19. Anyone who is uninsured and treated for COVID-19 may be covered under the CARES Act Provider Relief Fund. So even if you don't qualify for financial assistance and you are uninsured, then you may still get those bills covered if you had COVID-19. So, as I said, a very important population group of clients for us is seniors. So let's move on and talk about them. Medicare is a federal insurance for seniors 65 and over. As I mentioned, also for those receiving SSDI benefits after 2 years. And another group is individuals with end-stage renal disease. But the population group that you most associate with Medicare is those who are 65 and over. In general, Part A covers inpatient care in a hospital, a skilled nursing facility care, hospice care, and limited home health care. Part B covers medically necessary services to treat or diagnose a condition, as well as preventative services. Part D plans cover a wide range of prescription drugs that people with Medicare take, including most drugs in certain protected classes, like those with HIV, AIDS, or cancer treatment. Medicare Advantage plans bundle Part A and B, and they frequently include Part D. Generally, anyone who worked approximately 10 years will be eligible for free Part A, Medicare Part A. The standard Part B premium amount in 2020 is $144.60. Beneficiaries typically have a 20% patient responsibility for medical costs. A Medicare savings program is actually a type of Medicaid that covers the cost of Medicare premiums and or copayments. Qualified Medicare Beneficiary, or QMB, is the only Medicare savings program that covers both the premiums and the copayments. Individuals can apply through the Department of Children and Families, since it is a type of Medicaid. Extra Help lowers Medicare prescription drug program costs, including premium, deductibles, co-payments, co-insurance. This is not a type of Medicaid, but anyone who qualifies for a Medicare savings program automatically qualifies for the Extra Help. If you want to apply directly, you can go through Social Security. Long-term care Medicaid is a home and community-based service waiver program. It provides assistance in the home, in the community, or in an assisted living facility. There is limited funding, so anyone who is eligible is placed on a waiting list and given a priority score and a rank. So if your client ranks 5, for example, he may be taken off the list in a matter of weeks. Any ranking lower than that, and it may be months or even years. However, a nursing facility resident for at least 60 consecutive days is given priority enrollment and is not waitlisted. So that means, you can advise clients, if they're able to go to a nursing home for 60 days, 60 consecutive days. And if they still want to go back into the community, they will not be waitlisted. So Institutional Care Program Medicaid, or ICP, helps people in nursing facilities pay for the cost of their care. Unlike the home and community-based services waivers, like long-term care Medicaid, there is no wait list, and individuals only need to apply directly with DCF. I'm not sure, I think I mentioned with the long-term care, you need to contact the Department of Elder Affairs to get on the waiting list. But with ICP Medicaid, you can apply directly with DCF. With ICP Medicaid, Medicaid pays the difference between the patient responsibility and what the nursing facility charges under Medicaid. In general, all the patient's monthly income, except for $130 personal needs allowance, except for $130 personal needs allowance, must be paid to the nursing facility. So here is the SSI-related programs financial eligibility standards. I'll give you a minute to take a look at all of the various areas. You'll see that these are the income limits for SSI-related Medicaid programs, including Medicare savings programs, long-term care, which is a home and community-based services waiver, institutional program Medicaid. Note that the home and community-based services waiver and the ICP have a higher income limit of $2,349 compared with QMB, which is $1,064. However, if somebody qualifies for either the waiver or ICP Medicaid, they automatically get full Medicaid and QMB. So oftentimes we'll advise people whose income is too high for QMB to apply for the waiver if, for long-term care Medicaid, if they believe they need those services. If an individual's gross income is over the income limit to qualify for ICP Medicaid or home and community-based services waiver, like long-term care Medicaid, they can become eligible by placing the income overage into a qualified income trust account each month that they get Medicaid. The only thing is that the expenses need to be used to pay medical costs only. So if the person is significantly over and most of the medical costs are going to be covered by Medicaid, it might be difficult for the person to use the qualified income trust. Medicare covers COVID-19 testing with no out-of-pocket costs and antibody testing, as well as medically necessary hospitalizations, including quarantine. However, the hospitalizations are subject to copays. It will also cover COVID-19 vaccine when it becomes available. And Medicare has temporarily expanded its coverage of telehealth services and relaxed the HIPAA privacy standards. So it covers virtual check-ins and doctor communications through online portals. Unfortunately, active daily cases in long-term care facilities are going up in the United States and Florida. If you want updated reports and including a list of facilities with active cases, you can go to the Florida Department of Health COVID-19 page. So let's move on to another really important group for our clients, immigrants. Lawfully present individuals with work credits that qualify them for premium-free Medicare Part A do not face any length of residency requirements. That's something that people get confused with because oftentimes they think that all immigrants have to have been here at least 5 years. That's not the case if you have the sufficient work credits. Non-citizen immigrants who do not have the work credits, however, must be a lawful permanent resident, and they must have 5 years of continuous residence in the United States in order to qualify. An immigrant who is no longer subject to the 5-year bar, but who does have sufficient work credits for free Part A, may be eligible to get a Part A buy-in. So through the Part A buy-in, individuals can receive Part A and Part B for free if they qualify for the Medicare Savings Program of QMB. The application process can be very tricky, and we usually arm clients with a letter pointing out the Social Security rules called the POMS, because the representatives aren't always aware of this process. I helped a client recently, and usually they need to go to the Social Security office to apply. Since the offices are closed, I helped him to call Social Security and apply. And the representative immediately wanted to tell him to go to DCF first before letting him enroll in Part B. But they have to have proof of Medicare enrollment prior to getting the QMB. So that it wouldn't work if she declined his Medicare enrollment. She has to give him Part B and conditional Part A. The conditional Part A, the Part A will start as soon as the QMB kicks in. So anyone who is lawfully present is eligible to purchase in the marketplace. And you can see this is a very long list. So you'll see, for example, that any lawful permanent resident, regardless of 5-year, whether they've been here 5 years or not, is eligible to purchase in the marketplace. Also, people with non-immigrant status, including worker visas and student visas, can also be eligible. The list of qualified immigrants who are eligible for Medicaid is a bit shorter. Legal permanent residents are subject to a 5-year bar, with an exception for children in Florida. So this is a rule that most people are not aware of, including federally funded enrollment assisters and call center representatives. If you recall, most people with income below 133% poverty level were supposed to get Medicaid through Medicaid expansion. But this, of course, left out anybody who was not eligible for Medicaid due to immigration status. So a special exception was made for these immigrants. If their income is below 100% poverty level, they are eligible for subsidies, even where a citizen or a legal permanent resident over 5 years is not eligible if their income is that low. So that's something very important to remember. And like I said, a lot of people are not aware of that exception. So these lawfully present immigrants are not eligible for Medicaid due to their immigration status. That means that they are eligible for premium tax credits and cost sharing reductions if their income is below 100% poverty level. So a lawful permanent resident less than 5 years, not eligible for Medicaid. But if their income is below 100% poverty level, then they are able to get a marketplace plan with tax credits and cost sharing reductions. This is the one area where undocumented immigrants can get Medicaid. So an immigrant who is not qualified or who has not met the 5-year waiting period may qualify for emergency Medicaid if his or her medical condition is so severe that it could result in placing his or her health in serious jeopardy. One thing I forgot to note is that they still have to fit into a, they still have to be otherwise eligible for Medicaid in Florida. So they would have to fit into those Medicaid categories. So you may have heard a lot about this public charge rule. An individual who applies to enter the US or who applies for lawful permanent resident status is inadmissible if at the time of application for admission or adjustment of status is likely to become a public charge. Previously, a person could be determined a public charge if they were likely to become primarily dependent on the government for subsistence. The only benefits considered were cash assistance or institutionalization for long-term care. The definition of public charge changed in a final rule that was implemented this year. Now, a public charge is defined as an immigrant who receives one or more public benefits. The rule is going through a lot of challenges, but it is currently in effect. Anyone seeking care, however, for COVID-19-like symptoms will not have that considered in their assessment, public charge assessment. So these are the benefits that are currently considered under the public charge rule. Medicaid, except for emergency Medicaid, children under 21, pregnant women, and new mothers. SNAP food assistance, federal public housing in Section 8, and cash assistance programs like SSI or TANF. One thing to note is that most people who are subject to the new public charge rule are actually not going to be eligible for those benefits, particularly in Florida. So, for example, if you're not a legal permanent resident, if you're applying to be a legal permanent resident, you're probably not going to be eligible for Medicaid. All right, let's move on. The rule primarily affects immigrants seeking to enter the United States, immigrants applying for legal permanent resident status. It does affect legal permanent residents who leave the United States for more than 180 days for 6 months. The public charge rule does not apply to legal permanent residents who are renewing their status or applying for naturalization. It doesn't apply to asylees, refugees, survivors of domestic violence, temporary protected status or other protected groups, or active duty service members and their families. Last but not least, we're going to address medical services and billing issues. So all plans offered in the health insurance marketplace are required to cover these 10 essential health benefits: ambulatory patient services, emergency services, hospitalization, and so forth. If a marketplace consumer's claim for coverage of medical service is denied, they must file an internal appeal with the plan, not with the health insurance marketplace. And these are the deadlines for the internal appeals. They have to be completed within 30 days if the appeal for a service is for a service that they haven't received yet, and they have to be completed within 60 days if the consumer's appeal is for a service they've already received. Medicaid services vary depending on the Medicaid managed care plan the recipient chooses, the age of the recipient, and the medical necessity. These are some of the services included in the health plans approved by Florida Medicaid. Medicaid services for children are different than those for adults due to the EPSDT provision. States are required to make available early and periodic screening, diagnostic, and treatment services for individuals who are under the age of 21. It is a much broader definition of coverage. Although Florida applies the same medical necessity rule to children as it does to adults, the 3rd District Court has determined that the state's definition of medical necessity is overly restrictive when applied to children under 21. So I had a client who's a 14-year-old boy. He was enrolled in a special Florida Medicaid managed care program for disabled children. He had a rare genetic disorder that prevented that previous genetic testing and a muscle biopsy were unable to diagnose. His genetic specialist requested pre-authorization to perform a special genetic test called whole exome sequencing in order to determine a definitive diagnosis. The test was denied by the Medicaid managed care program for lack of medical necessity, and his mother appealed. I represented him, or I plan to represent him at hearing. I did extensive research and prepared a brief highlighting that the denial is a violation of federal EPSDT provision. Immediately after I submitted my brief, a week before the hearing, the plan's attorney contacted me and said that the plan finally agreed to cover the test. Generally, the Medicaid managed care plan's appeal process has to be exhausted first before a fair hearing can be requested. However, during the COVID-19 emergency period, you can actually file a request for a fair hearing directly with the Medicaid agency. An appeal with the plan should be filed within 60 calendar days of an adverse benefit determination. However, enrollees have to be given more time through their plan or request a fair hearing if the need for an extension is due to COVID-19 impact. So if a Medicare Advantage plan denies an enrollee's request for an item or a service, an individual should make a reconsideration request within 60 days of the adverse benefit determination. If the plan upholds its initial denial, the case is automatically submitted to an independent review entity, or IRE. If the enrollee is not happy with the IRE's decision, they have 60 days to request a hearing. The IREs may allow deadline extensions due to the COVID-19 emergency. There are 5 levels in the Medicare Part A and Part B appeals process. A decision by the Office of Medicare Hearings and Appeals can be submitted for review by the Medicare Appeals Council, which can then be reviewed by the federal district court. So if a pharmacy can't fill a prescription, the enrollee should discuss alternatives with their doctor and request a coverage determination from the plan. They can request an exception if other treatment options in the plan's formulary don't work for them. If they request an exception, the doctor will need to give a supporting statement to the plan explaining why the individual needs that specific drug. Part D appeals essentially have a very similar process to the Medicare Advantage appeals process. You get a redetermination from your plan. Then there's a reconsideration by the IRE. Then it can go to hearing and then review by the Medicare Appeals Council, and then finally judicial review by a federal district court. So our 72-year-old client was hospitalized 3 times for a severe back condition. After the 3rd hospitalization, she was admitted to a skilled nursing facility. So there had been a mix-up with her previous Medicare Advantage plan. The hospital had actually sought the pre-authorization with that prior Advantage plan, and the Advantage plan granted it. However, that wasn't her current Medicare Advantage plan. So her current one denied it 2 weeks after her stay in the facility. So she ended up being billed for $12,000 by the facility. The client appealed the decision, and I represented her at a Medicare hearing. The judge's decision was fully favorable to the client, and the Advantage plan was required to cover the $12,000. Tax-exempt hospitals are required to establish a written financial assistance policy. These hospitals must make reasonable efforts to determine whether an individual is eligible for financial assistance under the hospital's financial assistance policy before engaging in extraordinary collection actions against that individual. Florida also has charity care requirements. Hospitals owned by corporations that are not for profit under Florida law must provide both Medicaid and charity care. What's called the low income pool provides direct reimbursement to safety net providers for uncompensated care. So essentially, if the individual's household income is less than 200% poverty level, the bill will likely be covered. So Florida is actually one of the few states to have balanced billing statutes, and this law is actually being used as a model for a possible federal law. A provider can't bill an individual in Florida if they know it should be covered by the patient's insurance. And an out-of-network provider cannot be reimbursed more than what was in the coverage terms of the health insurance policy, and can't attempt to collect anything beyond the required co-payments, co-insurance, and deductible. So this is a complex example that essentially incorporates almost everything we talked about today. And this is a real example. The client was a college student who had been a legal permanent resident for 3 years. She had income of about $4,000 a year. She lost her health insurance marketplace coverage and was told by a marketplace supervisor that she was ineligible for tax credits since her income was below 100% poverty level. The supervisor told her she was in the coverage gap. Tragically, shortly after she lost her coverage, she had multiple hospital visits due to a sudden illness. She came to us several months later for help with the bills that were hundreds of thousands of dollars, and only some of those were from charitable hospitals and covered by financial assistance. There were still thousands and thousands of dollars that were from private hospitals that were not covered. I recognize that this client qualified for the special rule for those immigrants who are able to qualify for subsidies in the marketplace since they're ineligible for Medicaid due to their immigration status. I assisted her in pursuing a marketplace appeal despite being past the 90-day deadline. The appeal was dismissed, but I drafted an explanation stating that the supervisor's misinformation led the client to believe an appeal would be fruitless. So that's why she didn't appeal on time. The dismissal was vacated and the client was successful on appeal. Fortunately, that's not where it ends. So we called the claims department of the insurance company after she won the appeal. They saw that she was successful, and they said that they were going to resubmit all the claims, and they would send a detail of what was covered and what copays she still owed. However, a few months later, she started getting collections notices for more than just copays, for much larger bills. The problem was that the plan somehow didn't have all the claims from that time period, and it was over a year since the date of the medical services. So any provider that tried to submit a claim, it would not be covered because it was too late to submit. However, I contacted the providers and I argued that under Florida law, they can't bill the client because they're not covered. I'm sorry. So I contacted the providers and argued that they could not bill the client under Florida law, even if the bills were not being covered, since she was covered by an HMO at the time. After sending proof of coverage, we managed to get all the bills pulled from collections. So that was a lot of information in a relatively short period of time. So I know it can be a little overwhelming, and I'm sure you have a lot of questions.
That was a lot of great information, and I sure am glad there are people like you who understand all this and can help clients through it. I can't imagine how stressful that is to be going through medical problems and then have $12,000 bills and collections notices. So thank you for guiding them through it. So we did have several good questions come in. I will start at the top. The first one is asking you to look into your crystal ball and let us know, what is the likelihood that the Florida legislature will expand Medicaid?
Unfortunately, I don't have a crystal ball. And yeah, I also work for an LSC funded organization and probably cannot really talk about, that side of things, unfortunately. Sorry.
That's okay. Next question is, where can we get more information about parent caretakers eligibility for Medicaid?
Okay, well, I have my contact information is at the end. You can send me an email and I can provide you a lot of links. Also, I forgot to mention, if you look at the slide presentation, there are links at the very bottom. Let's see, not there, but you see at the very bottom, I have like the statutes here. When I talk about that section in the slide, there are links or statutes, so you can go to that section. I believe I may have put a link to the family-related Medicaid fact sheet. You can also, so just Google Florida Medicaid, Florida family-related Medicaid fact sheet. You can also look for the Florida Program Policy Manual, and that has all the information. You just go to, if it says FAM, F-A-M, that's family-related Medicaid.
Okay, I'm just typing the Florida Program Policy Manual in here. And I'll also type Margaret's email in the chat box. And this is recorded, and I will send out the PowerPoint tomorrow along with the recording. The next question is, I note there are many asset limits for SSI-related Medicaid, but did Margaret say there are no asset limits for family-related Medicaid on the colorful chart?
Correct. Yes. There's no longer an asset limit for family-related Medicaid, only SSI-related programs.
Okay. And the next question is about COVID testing. Is there a limit to the number of COVID tests per month an individual with Medicare can get? Or would they need a doctor's prescription for multiple tests? Or can
That's a good question. I actually don't have the answer to that question. I would have to look it up.
Okay. So we will follow up with that answer in the follow-up email. Where can we get more information on Medicaid eligibility for immigrant applicants and the work visa exception?
Are you talking, when you say the work visa exception, I'm not sure what you're referring to. Are you talking about the exception for marketplace? Do you think they're talking about the exception for eligibility in the marketplace?
Let's see. I'll see if he can follow up and clarify that. All right, so while we're waiting on that clarification, we'll move on to the next one.
Well, like I said, there are links in each slide. So we're going to send out, Christy, we can send out the slide presentation afterwards. Yeah. Yes. And so it's very small, but if you just click on that link or, copy and paste the citation, you should be able to find it. Another good resource is that I cited a few times is the Florida Medicaid Advocates Guide. I don't know if I have that exactly correct, but I helped to co-write that with Miriam Harmatz. So that's a good resource with a lot of citations. So
okay, I just typed that in the chat too. Does emergency Medicaid for those not lawfully residing or who do not have legal status cover someone in need of a transplant of a vital organ?
So what was, can you repeat the question? I'm sorry.
Does emergency Medicaid for those who are not lawfully residing or who do not have legal status cover someone in need of a transplant of a vital organ?
Yeah, again, I would have to, that sounds like a very specific question for a very specific client. And I think that there's probably going to be a lot more to that facts needed to answer that question. Like I said, it's just for emergencies. I don't know what degree that's considered an emergency. I would have to research that. And I think that you would need not just to research that question generally, but the specific facts of that case.
Okay. Oh, sorry, the dogs are barking. Must be someone at the door. Can you tell us more about the legal theory of your win for the lady whose Medicare Advantage plan failed to cover her hospital stay?
Okay. Let's see if I recall. That was a little while ago, so I have to go back and look at the details. But basically, they weren't considering her case as a whole. They were looking at the they were saying that she could have lesser care, a lesser level of care. So for example, they were suggesting that she could go home and have home services. However, she tried that for a week, and that was one of our the things that we pointed out, that after she was hospitalized, between the hospitalization and going to the skilled nursing facility, she actually was home for a while, and she lived in a place with stairs and with no, her home was not set up for somebody who could not walk. And she had to sleep in a bed that was, not a real bed on the first floor. And it just made her condition got a lot worse after that week at home. So, and also I pointed out that she was getting a lot of medications, like opioids, things that required a lot of management, that they weren't looking at her case as a whole and considering everything. And so the ALJ agreed.
So nice when there's a happy ending.
Yep.
So we have a question about the next client example you gave in part 2 of the complex client example. Were you able to use the balanced billing argument with the providers, even though the client only obtained the HMO coverage after the fact?
Yes, exactly. Mm-hmm.
Okay.
Yeah.
Okay. You all are on top of things. And then Katie DeBreer posted the Advocate's Guide to Florida Medicaid Program.
Yeah, I know I wasn't saying that right.
Yes, so just trying to see if I can copy and paste that, which it's not letting me do, but it's in the Q&A box. If everyone's able to see that, I'm not sure if participants can see the Q&A box, but thank you for posting that. And let's see if we have any other questions. That looks like all the questions. I do want to announce the CLE number before I forget. I put it in the chat box, but in case you're joining on your phone or can't see the chat box, the CLE has been approved for 1.5 credits. There you can get 1.5 general credits or 1.5 health law credits. The CLE number is 2008 091. N is in Nancy. Again, it's 2008 0N091. N is in Nancy. So thank you so much, Margaret, for all that information and for taking so many questions at the end.
Thank you again for having me.
Yes, and she's generously shared her email address, and I will send the PowerPoint out to everyone tomorrow along with the recording. So thank you so much for joining us today, and I hope you guys have a good rest of the week. Bye-bye, everyone.
Bye.